program called FACEAP, which is the Virginia Alcohol Safety Action Program. They have a specified juvenile program for substances, and alcohol is one of those. Sometimes they order a specific substance abuse evaluation, and then they're asked to follow the recommendations of that. Other conditions will be community service, and in the juvenile court, sometimes it's a 25-hour community service penalty, sometimes it's a 50-hour community service penalty, and it's a judge's discretionary call when they choose to use. When they suspend a license, it's an automatic 6-month license suspension. And again, with juveniles, because some are actually licensed at the time, and there is a disparity with the adult underage alcohols, which is the 20s, 19s, and 18s, and the juveniles, and that the judge in the adult court may suspend the license, and the judge in the juvenile court has to suspend the license. It's a legislative thing, it's not a discretionary thing, and I don't venture to figure out why they made a difference, so I think we got to learn. In the juvenile court, when you come in on an alcohol charge, first offense, you're automatically first offender eligible, which means that you don't have to have a conviction. The court can do an evidence-sufficient finding, defer the case for 6 months, and put the terms and conditions in place. The terms and conditions are the community service, the suspension of license mandatory, and then also the FACEAP or substance abuse program. In the general district court, he can do the same thing, the judge can do the same thing if he wishes. If after the 6 months that there's all compliance, then the court can dismiss it. And that I think will be important when we talk about ramifications. I think it's the idea that they want to give incentive to perform correctly, be a good behavior, don't drink and drive, don't comply with the substance abuse or do community service. They recognize that these are juveniles, they recognize that these are first offenses, and they want to, although address the issue, they want to really work to the rehabilitative side of things, and that's why the dismissal is potentially available under the statute. If it's a second offense, however, the case cannot be deferred, and then the license can be suspended up to 1 year. And again, that's in a conviction, or you have to do the 50 hours of community service, so you have to do the $500 fine. And our judge, if you're on a second offense, not going to keep you the community service option the second time. He's going to say you're going to pay the fine. You had the lesser option the first time. Now you're going to take the more significant penalty. Our judge is very stern on those kinds of issues. My involvement, or the way I get involved, is that these are the people who make contact with someone who's possessing alcohol underage, and they will initially either make contact and release someone on a summons. They will also sometimes obtain a petition, because petition is a juvenile charging document, or again, with the 20, 19, or 18, they were always released on a summons. So then it comes to court, and then I become involved. And the way I become involved, particularly in juvenile court, I look and first assess eligibility for first offender. I look at the facts of the case, and I look at whether it's a FACEAP type case or a stronger substance abuse evaluation and treatment case. I look at the evidentiary strength of the case, whether we can prove it on all 4 corners. And then I appear in court and I give the judge guidance as to the facts of the case and also what the appropriate handling is under these sort of conditions that I've laid out, whether it's first offender, whether it's conviction, whether it's priors. We tap into the sort of juvenile court service reference and determine whether there's priors in other jurisdictions, because it's not just jurisdiction specific. And then if there is a trial, actually question the officer, put on the evidence, and prove the case, and then make recommendations. The most important thing I think we're talking about here are the implications of the juvenile alcohol or the underage alcohol charges. First of all, if there's a conviction, of course, a conviction is a permanent thing on the record for a period of time. Now, again, if there's a difference that the 20, 19s, and 18s, it's on their record, criminal record, forever. Juveniles who are convicted of class 1 misdemeanors, those records become expunged after a period of time, even if they're convictions. So there's, again, a difference in the law. But a conviction is still a conviction for a juvenile it's for 5 years after you turn 19 or after your last time.